great to see so many people in the audience on a Friday afternoon. You're very dedicated to the cause of privacy and data protection. And I'm delighted to be chairing this discussion, our first panel with Helen and Herke, as Michelle has alluded to. We've had many keynotes over the years. We've had many panel discussions, and we'll have another one after the break. And we thought it might be interesting to have a discussion and reflection really on where we are 10 years on from the GDPR being adopted, and also looking a little bit to the future. And we could have two no better speakers than or contributors than Helen and Herke. Helen, I'm sure, is familiar to many of you. Helen's an experienced leader in the public and private sectors with an international track record, as her bio tells us, but she's known to most of us as the Commissioner for Data Protection over a 10-year period, where Helen was really at the coalface in terms of the implementation of the GDPR here in Ireland, which was such a centre point of activity, not only for us here, but also across the EU. Helen served 2 terms from September 2014. She then joined the Commission for Communications Regulation as a Commissioner, and recently in March of this year, she joined Mason Hayes and Curran as a global digital regulatory consultant. She's also an independent non-executive director at REPAC. Herke is a member of the Legal Service of the European Commission. He works on legislation concerning digitalisation, advising the Commission, also appearing in litigation before the Court of Justice. He's also chair at the University of Maastricht in the area of European data protection and privacy law. And previously, he worked at the European Data Protection Supervisor. And Herke, I think to those of you who don't know him, he has joined us here before for the annual review of European law, speaking on data protection. But there's no one who's appeared in more of the big cases before the Court of Justice over the last 10 years than Herke. He's been in all of the big cases, has unrivaled expertise of this area, and is held in huge regard by the court in Luxembourg, but by others working in the area around. So we're delighted to be joined by Herke and by Helen. And really, I'm just going to facilitate, hopefully, a discussion on where we are with the GDPR, looking back 10 years and looking forward. And I suppose on that note, Helen and Herke, we might start with just looking back briefly, because, you know, when you think back to 2016, when the GDPR was adopted, after, you know, a long negotiation process and lots of lobbying, as we know, and so on, it was kind of a different world in a way. Obama was still in the White House. The Brexit referendum had yet to happen. And then the GDPR came into the scene. And obviously, there was a 2-year period before it took full effect. But I'm just wondering, based on your experiences, Helen, as regulator, Herke, working very much in the legal service of the Commission and before the court, what are your reflections now on that early period when the GDPR was first adopted and before it took off in full flight? Helen.
Thanks, and good afternoon, everyone. It's hard to believe it's 10 years in force now, and yet it's true. I think when I look back to when the GDPR was adopted in 2016, it certainly was my impression from where I sat in the regulator's office in Ireland that the GDPR was broadly welcomed in the sense that Europe already had a strong data protection law in the 1995 directive. It had all of the principles there, but there were definite issues of fragmentation and weak enforcement, weak public and private enforcement. So the GDPR, in a sense, was welcomed as anticipating some of those problems and providing solutions to them. So it had a big focus on harmonization, through the one-stop shop in part, and also by virtue of the fact that it was a regulation. So I think, notwithstanding that there was always a lot of publicity around the fact that at the time it was the most lobbied against law in the EU, I still think there was a recognition that it was needed as a successor to the 1995 directive. But as we might get into as we talk some more in detail about the GDPR, as I look back, I see it now as a great strategy, but one which lacked an implementation plan ultimately.
Okay, thanks, Helen. We'll come back to that. Herke, any thoughts on that, just in terms of bringing ourselves back to that early period, 2016 to 2018?
Well, I can only echo that indeed it's 10 years ago. The time flies. But let me first of all thank you for inviting me here. I'm very happy to be back here in Dublin. And I'm also honored to be here with the two of you. So I must say, David, we meet each other regularly in the Court of Justice in Luxembourg. And I don't know if people know this, but on data retention, David is very strong and a good fighter for perhaps a bit more approach towards creating some possibilities for law enforcement. But your input there is hugely appreciated, and I'm always looking at you as, okay, this is how I would like to plead. Although the court did never really change his mind, but that's another stuff. And Helen, you're a celebrity in the data protection world, of course. So the head of the DPC with all those big cases, the fight with Mr. Schrems, it's really an honor to sit next to you. So if you think 10 years back, I was thinking about it because I moved subject after 10 years also. I went now to deal with the AI Act and cybersecurity. And the AI Act is a bit in the same phase as the GDPR was 10 years ago. So 10 years ago, it was adopted, but not yet into force. AI Act is partly into force, but not yet completely. And what is the big difference? I think at the time, it was more awareness of that you have to comply with the rules of the GDPR, because the rules were already there. The directive, there's not that much change in substance of the rules of the directive towards the GDPR. But people, because of the fines, suddenly thought, we have to comply with these rules. And that was why there was so much stress those 2 years. And there was already a lot of guidance from the predecessor of the European Data Protection Board, the Working Party 29, etc. So compliance was the key feature. While with the AI Act, we are in a bit of a different ballgame. There were no previous rules, and we are regulating a new technology, AI. And a lot of the guidance is not there because it's all new rules, and a lot of guidance must not come from a board like under the GDPR, but from the European Commission. And what you see now is that with so much emphasis put on that guidance, which needs to be there in order to be able to comply, there's actually a lot of pressure on the Commission to make it actually be workable. And that's also why recently there was this agreement to postpone at least a part of the AI Act to a later date in order for it to be ready to have all the means in place to be able to comply with those rules. So if I look back, it was more an awareness, and now we have to comply with those rules, than if I now look at the AI Act, where it's much more uncharted territory.
Okay, no, thanks for that, Herke, and thanks, Helen. And I suppose moving forward, and that what you've mentioned raises questions about realistic expectations were around issues such as implementation. And even though the rules were somewhat familiar from the 1995 directive, there was still a big piece of work to go. Helen, where do you think 10 years on we stand, accepting that there are lots of difficulties in carrying out such an assessment? What do you think at this stage stand as the successes or the strengths of the GDPR?
Yeah, so to focus on the successes, and I think there have been many. First of all, I think the appointment of so many new data protection officers certainly has delivered more data protection on the ground. And in Ireland in particular, I could see over time the professionalization of DPOs in the public sector in particular, and lots of different networks, informal networks of DPOs forming, where DPOs were sharing information and war stories with one another, and really starting to help each other out in very pragmatic ways. So I definitely think that's been a big success. Awareness has also been a success of the GDPR, whether it was the fines or some of the big enforcement cases. It's certainly come to much more prominence, and there's much more awareness of what the requirements are. I think there's been some good guidance, but that cuts two ways. There's been some bad guidance as well has come out of it. And I think another one of the partial successes has been the one-stop shop, because I think it for all its deficiencies, and there's been much written academically about those deficiencies as well. I think the cases that went through the cooperation and consistency mechanism, and actually ultimately the dispute resolution mechanism, have in fact delivered some of the strongest harmonized interpretations. Whether we agree with where the interpretations landed or not, at least it gave certainty on the interpretation of key aspects of Article 83 on the application of fines and so on. So I think there have been missed opportunities in the one-stop shop, but it's been a partial success. And then there have been thousands and thousands of complaints resolved to the satisfaction of individuals, lots and lots of case studies produced out of them that have given onward guidance to organizations in trying to comply with the law. And we've seen as well, and again, a lot of these successes are kind of cut both ways, but we've seen a big increase in the number of preliminary references from member states to the CJEU under the GDPR because of the number of issues that aren't act clear. But it's been a success in that we've had a lot of good new case law coming out of it. So the list of non-successes.
And we come back to that. Yes. I'm sure there will be some in the audience as well. Looking from your side, just in terms of when you look back to, where we were and the data protection reform package originally, put forward by Vivian Redding and so on, to what extent has the GDPR 10 years on met some of those key goals that the Commission in particular had identified back then?
So just to note that I work at the European Commission, but I speak on a personal note today, which allows me to say a bit more than only what the Commission should say here. I think that the GDPR can be called a success. If you look at the objectives at the time, it was about making the law being applied in practice, because it was a law which was mostly not applied in practice, not complied with at all. There was this big gap between the law and practice. And the GDPR has changed this. People have become more aware of the existence of the rules. Individuals have become more mature and more aware of the rights they have. That was also very important to achieve with it. It was strengthening the rights of individuals. It has streamlined the rules, the obligations which are put on controllers. Of course, there are always questions of whether these are not too cumbersome, whether there should be some red tape cutting, but still. And the fact that it's a regulation and not the directive has really helped avoiding all this fragmentation between member states. I'm not saying it's all fantastic, obviously. And when I listen to you, and indeed a one-stop shop, it works, but it feels also like it's still work in progress with the GDPR. Every single decision has been challenged in the big cases, and are still out in the court of, now first in the general court, and then it will of course be appealed. So it will take really still a lot of years before we know exactly how this system, according to the court, plays out. But generally speaking, and also now that I'm working on all those new areas, like there will be a new act on data sovereignty, the Cybersecurity Act, the data, what is the Digital Network Acts and the FAIR. There are all these acts still in the pipeline. And if I look, if I speak out freely at the quality and the simplicity of those acts compared to the GDPR. I know the GDPR can be seen as complicated, but the GDPR is in a way quite nice piece of legislation. And I think also with the Court of Justice, with these many rulings, has also created clarity. And we will talk about the court later, but we can be quite happy in that respect with the GDPR and where it stands now.
And Herke, I suppose picking up on Helen said, some partial successes, and we'll come to kind of some of the challenges or weakness. From your point of view, what kind of challenges or weaknesses have become most apparent in the past 10 years with the benefit of that experience?
I think there are two issues here. One is the scope of the rules. We all know that in those 2 years between application and entry into force and application, there were all these wild stories about schools that could not take pictures of children anymore. They were all standing backwards, and at sports clubs. And for those, it's difficult to understand why this heavy machinery of the GDPR lies on them, right? And you see, with the Court of Justice, the Court of Justice almost exclusively takes an expensive approach from the perspective of the data subject. So if it's about protecting a right, it should be interpreted broadly. That's basically what the court says. So every single notion like controller, data subject rights, or just the scope of the regulation has consistently be interpreted broadly. And that brings a lot within the scope of the GDPR. And that is a risk. That might make it impractical, but it might also lead to, and that for me is a sort of central theme, loss of support for the rules. If you overdo it, people will no longer believe in it. Second thing is the enforcement. So people were very anxious about those fines, and they have, of course, been issued. But in practice, maybe if you're a smaller organization, the threat of a fine appears not to be so apparent, actually. So I think where you see a sort of peak, and this is all because we don't have the figures, but my feeling is that in the beginning, everybody was very nervous and trying to comply. And now people start to understand that if you are a bit in between, you will not necessarily be in the eye of the supervisor. And for me, what is key is, again, for support, is that the rules are actually enforced. And although I see the benefit, and this is really on a personal note, but although I see the benefits of the one-stop shop and a whole system that has been created, and we have now a new procedural regulation, which will sort of make it more streamlined, the procedure for cross-border cases. I think there we need another solution. And the solution is not to streamline those procedures, but if we are to think openly about the future, I would say that the bigger cases, the cross-border cases, should go to the European level directly instead of this very complicated, cumbersome system of one-stop shop.
Okay, creating more work for your colleagues in the Commission. Helen,
It would not be the Commission, it would be
you're outsourcing
independent authority.
Very good.
Protection point of view then.
We'll come back to that, Herke, because that's an important reflection piece. Helen, just on the kind of challenges, weaknesses, or partial successes, the flip side of that, perhaps, what are the most striking aspects for you, given your experience at the coalface as regulator?
And I'm taking it by you asking me the most striking aspects that I shouldn't give my full list, which can go on, and it's not to negate the successes. And I fully agree with you, Herke, that our minds have to be open to all sorts of different solutions to what we see as the challenges. So while I have a couple of things maybe to say about the idea of centralizing the cross-border cases in an independent EU level authority, I agree, it should be on the table. Maybe just to pick up, first of all, on what Herke said about the scope of the law. We've seen Advocate General Bobek, when he was at the Court of Justice, call this out in several of his opinions, that there's almost no aspect of human life that isn't getting caught within the GDPR. And he was predicting, as he was departing the court a couple of years back, that either the legislator or the courts were going to have to revisit. And when you map that very broad scope onto the role of a supervisory authority, a national data protection authority, not just the volume of complaints, but the type and nature of complaints that authorities are dealing with is just so incredibly broad. So an awful lot of what are effectively employment law disputes come as data protection issues. Neighbors disputing the location of CCTV cameras that are really long held feuds between neighbors coming, members of golf clubs that are fighting with each other over scores and then checking CCTV to see. So all sorts of things come into the melting pot. And because the GDPR doesn't set out any enforcement priorities, and you end up as an authority dealing chronologically with this endless list of complaints that are of different severity in terms of any potential impact on fundamental rights, it becomes a somewhat inefficient system in terms of tackling what are the big issues. And I have called out in an article I wrote for IDPL last year that the GDPR, I don't think, is a clear enough path for supervisory authorities to deal with big systemic issues that affect everyone. So an awful lot of emphasis on the pathways in the GDPR is on complaints of individuals or representative bodies lodging complaints. And it hasn't, in my view, always been the most useful lens through which to look at some of the big systemic issues. If I get on to some of the challenges with the one-stop shop, because of course the Irish Data Protection Commission was very concerned with those issues, I said at the outset that I think the GDPR is a great strategy that lacked, at the time of its coming into force, a detailed implementation plan. And what we found as we began to operationalize cross-border investigation cases is that there were no procedures that were clear or laid down. We were really pathfinding as we went and leading the EDPB in terms of understanding what its role was. So complications around the language in which objections might be lodged in terms of an Article 60 decision, draft decision put forward. Was the regulated entity entitled to a copy of all of those objections lodged? The DPC said, well, yes, of course, as a matter of fair procedures. The objecting authorities said no. So there were just every single step of those early cases was disputed, not in a, we're all going to fight and fall out way, but just in a, will we see this differently kind of way. And of course, all of this, to express it quicker, is to say that the administrative laws were not harmonized at all and the procedures were not set out in any detail. So some of those things are still unraveling. For example, we all know the EDPB interpreted the role it had under the GDPR as signifying that its decisions under Article 65 couldn't be subject to direct attack. And now we've seen that position clarified in the opposite direction by the courts. So at an EDPB level, I will use the word chaotic for the early cases in terms of unraveling what the procedures to apply are. And of course, some of that is still playing out through the courts. The last thing I'll mention just on challenges, and we could spend the whole day on the challenges, is the issue of, and Herke mentioned this, time. We are 10 years into the GDPR being in force, 8 years into it applying, and the biggest cases are still going to be many more years completing out the cycle before the European courts and then back to the Irish High Court in some of the cases. So it's a slow process. And I'll hold off and come back maybe later to that idea of centralizing the cross-border cases, because sorry, the one thing I do want to mention before I stop on the challenges is that, of course, the vast majority of complaints handled and enforcement happens at a national level. So you're then taking a tiny subset of cases, albeit very big cases, that go through the cooperation and consistency mechanism. So you're fighting against very entrenched national interpretations. It's well known the Dutch DPA interpreted for a long time, until the courts recently found against it, that commercial interests could never be legitimate interests under the GDPR. And that's fine. That's ultimately the kind of dispute the EDPB had to resolve. But I suppose it's very difficult to talk about harmonization when most of the cases are dealt with in a way that is not harmonized at national level. And when the compensation cases, the private enforcement was also a big new innovation in the GDPR over and above the 1995 directive version. And there isn't really a harmonized or you know, it isn't possible to have a very harmonized approach to those either.
Yeah. And Helen, how much of that, particularly on the public enforcement side, do you think is kind of an understandable bedding down of any new regime, particularly where it's, you know, a novel regime with very unusual features, or do you think some of it is inherent in it?
Yeah, no, sorry, I was going to say, I think it's much more than typical bedding down. It's because of the novelty of that form of one-stop shop and the kind of limited decision-making role the EDPB had, you know, which allowed it to interpret that it wasn't going to be directly subject to annulment actions on its decisions. It's, I think, because of the novelty and the absence of what is now the procedural regulation. So, I mean, there's been course correction, a recognition that you can streamline some of this by doing a limited harmonization. And I think, you know, another aspect of it is that the GDPR being technology neutral, principles based, controller neutral. I think there's also been a course correction in terms of recognizing you cannot regulate the internet platforms just through the GDPR in terms of all that arises. And so we've seen the DSA, the DMA, we'll have the Digital Fairness Act. There is so much more that's needed to tackle all of those. One very last point, since I mentioned controllers, is when the GDPR was introduced, it rightly sought to eliminate some of the kind of useless red tape requirements under the 1995 directive, one of those being a registration requirement. But I think I've realized that one of the advantages of the registration requirement, whether entities got it right or wrong, was that they had an accepted status. And I think one of the issues with being a controller, being a processor, being main established, being a legal status rather than a registration, is that all of those are disputed in almost every big case as well. So there's shifting sands, I think, in a lot of it, and some of it will improve with time, but I think course correction is going to be needed to fix some of it, and that's already happening.
Thanks, Helen. That's very interesting. And Helen's editorial, guest editorial in the International Data Privacy Law is well worth a read for anybody who hasn't seen it. I think it has the provocative title, Helen, "The GDPR is not loved, but does it work?" And it just traces some of the difficulties in evaluating it. And one of the things that struck me in it, Helen, is that you rightly in your conclusion say the GDPR was always going to be a long play. It's going to take time for some of these intricacies to work out, and we've certainly seen that. Moving away from the kind of the regulatory focus and maybe more towards the court, Herke, the court's obviously been a huge player in the GDPR as well. And of course, the court isn't approaching it in isolation. It's doing it now armed since the Lisbon Treaty with the Charter of Fundamental Rights, which has had a big effect, I think, on its approach to the interpretation of the GDPR. How do you evaluate the role of the court vis-a-vis the GDPR over the past kind of 10 years? I know that's a very big question, but has it helped in terms of providing the clarity you talked about, or are there any issues with its jurisprudence that you think may require a course correction of the kind the legislature has provided in some respects?
The role of the court has been massive on the GDPR. I think there are about 150 cases, preliminary rulings the court has issued under the GDPR, maybe a bit less, but more or less. And it has really made sure that the rules are clear, or at least that the questions that are asked have led to clarifications which were desperately needed in practice. Of course, I'm not saying that every single ruling was always crystal clear, and there are cases which have been which led to yet other questions to the Court of Justice. But generally speaking, the court has really confirmed the GDPR in its objectives as well. That being said, it's a bit of a hobby horse of me, but what strikes me, and by the way, it also helped us in the legal service a lot, that the court once in a while actually declared something invalid, which the union legislator had adopted, or that it disagreed clearly with a position we had taken somewhere else. That if you are as legal service, you need to advise internally the commission. And now if you would say, well, we think this might create problems in court, suddenly we were listened to, since the court started with the Schecker ruling, but later on with other striking rulings, of course. But when looking back, we may be very happy with what the court has done. It's very protective towards the individual, as I already said, and broad interpretation of notions constantly. But I tend to feel now that the court perhaps needs to take into account other interests at least more explicitly. And if you look at the two objectives of the GDPR, they are on the one hand the protection of the right to data protection, and on the other hand the free flow of data, to put it simple. So those are the two objectives of the GDPR. And if you, with those objectives in mind, look at all the case law of the Court of Justice, you see in the very beginning, because these were similar objectives under the directive, when it's about the independence of the Data Protection Authority. So we're talking about case law of 2010, so far before the GDPR. And there the court said these authorities must be independent because they have to make this assessment between, on the one hand, commercial interests, the interest of a free flow of data, and the protection of fundamental rights, in particular data protection. Since then, 2010, it has been repeated in two similar cases, 2012. It has never occurred again in the case law. So all those 140 cases have not, 50 cases have not referred to the second objective anymore. And that's interesting because in my view, the court should take it into account, and maybe to quite a large extent, it also applies to the data protection authorities and the board. Just look for it. How often is that interest as a counterbalance to the protection actually addressed in those rulings and advices, guidelines, etc., opinions? And it might feel a bit like semantics, but if you have to at least refer to the second objective, you're also forced to explain why the preference goes to data protection instead of this free flow of data. And maybe it sounds a bit abstract, but maybe I can give an example. Is one case, I think it's the Punky case, where the question was, do you have a right of access to the log data of who in the house of a bank had access to your account? Is that your personal data? And do you have a right of access to that data? The position of the commission was, no, you don't have access to that data because this is part of security. Requiring a log file of who has access, it's a security measure. And the log files, as you see under the law enforcement directive, are per se something for the supervisors to check. So they can come along, you complain, they come along and check, and then they can check the log files. But is it really necessary for every individual to have access to the list of data of people that had access in the house, or the employees to your account, for instance, so information about your account? And against the background of free flow of data, or free flow, but the interest of the companies more generally, and the right to data protection, you could argue this puts a lot of burden on the companies, because you can also come along and ask for that data as an individual. And of course, there are many people that do it. I'm not arguing against a proper right to access, but in this case, you could consider perhaps to shift it to the other side. And that could be done with reference also to the second objective. But the court never does it. You will, if you read the cases, you always see, recital 1 and 10, the objectives of the GDPR are, they do say inter alia, but the high level of data protection. So, and I come back to my central point, we should not lose support for the rules. And you see if the court continues to constantly, let's say, and also for data protection, if the wind always blows from one side, you could say, always more protection, more for data subjects, intrinsically I would agree, but there is a limit to it, because otherwise it gets too much. And then you will lose support. People will not believe the rules anymore, or they will not comply, or they're not able to comply anymore if it's so broad.
Okay, that point very well made, Herke, and I suspect, Helen, that's something you've had to deal with in practice in the DPC navigating these court rulings, and particularly the breadth of them, just in terms of how big the scope is in practice of the GDPR and where the limits are.
Yeah, but of course I would agree with Herke. It's incredibly useful for data protection authorities as well to get judgments from the court. I was talking to Herke previously about the issue of the European Court not being a court of facts. It doesn't find facts. It relies on the preliminary reference from the member state. And often I find it's a pity that sometimes the facts aren't as comprehensive and well bundled up. And I think the judgments that are most useful are the ones where the facts are complete and the court is really then making a very precise finding on facts. The ones where it's a little bit more abstract and it goes on to say it'll be for the national court and really leaves it back to the national court can tend to be less useful. We saw with, for example, the Bundeskartellamt case where the case then settled and we didn't end up with a final ruling before the courts in Germany, and there was lots of interesting stuff in that one. So yeah, there was something else Herke mentioned on the complaints and the scope of the complaints. And sorry, I'm back to challenges, but I'm citing it as a challenge with a view to, there's an opportunity perhaps to streamline some of these things under the procedural regulation. But one of the challenges over the last 8 years has been a refusal to legitimize informal or amicable resolution of complaints. And in fact, amicable settlement of complaints is a really pragmatic solution, often for the data subject, because they're getting resolution of what they want. But in fact, on cross-border cases, many of the EU data protection authorities would refuse to recognize an amicably resolved complaint and would insist on it going through the full Article 60 process. And again, that's simply using up resources. So I think it's positive, and I hope it'll lead to some positive change that under the procedural regulation, the EU legislator has now formally recognized a process, albeit it still involves some steps around amicable resolution.
Thanks, Helen. And before we leave this topic, I should point to a flag another great article. This is by Herke this time, which is about the return of the second objective of the GDPR from the 2025 European Data Protection Law Review about profiling data availability and AI. So very interesting. And that brings us, sorry, Herke.
Yeah, can I add just a little thing on what I just said? So, because I don't want to give the impression that I'm highly critical about the case law of the Court of Justice, because I think, again, they did a great job. And you mentioned Bobek, Advocate General Bobek, who has several times attempted to bring in some reason in the reasoning of the court in relation to data protection. He actually literally spoke about this introducing a rule of reason, which we of course know from other parts. Because he has the example, that's the famous example where he says, I'm with a group of friends, I get a message drinking a beer in a pub, and I get a WhatsApp message from somebody with a gossip, and I share it with the others. Does the GDPR apply? And then he said, the representative of the Commission could not answer that question. We time and had questions. We still But when he, because he had one term Advocate General position, and he suddenly left to my feeling while we had so many interesting exchanges. I sent him a message saying, listen, thanks for all the interesting debates. And then he said, yes, but please note, I'm just trying to protect the data protection rules by trying to introduce these kind of the rule of reason like communication. So he said, I'm not intrinsically against those rules, on the contrary, but I'm trying to protect it. And I think that's the same feeling I have about it.
Yeah.
We should be very careful now, because if we overstretch, not only support, because support is in general terms, not only the data subject or the controllers, but also the legislator. We are now in an era, and we will talk about it, but where everything is suddenly under discussion. The first omnibus which touched the GDPR was just about the notion of SMEs. And now suddenly we have a digital omnibus, which actually starts mingling with the notion of personal data, the key notion of. So if there's, and you see it a bit also in the data retention context, if there's too much overzealous interpretation, the legislator might start to correct it. And I'm not so sure if that's what we want, because there it might go ballistic. Huh? I've just come out of a night trialogue on this AI omnibus, which was about this problem, and also introducing this Grok, the unification app prohibition. Well, the way this is last minute drafted, I hold my breath for this one.
Yeah, and I suppose one of the points that could be made at this stage is the space for that debate between, you know, the different objectives and all of the how it manifests in particular areas has been shrunk quite a bit by the Court of Justice and some of its jurisprudence, even in terms of the space that's left over for the legislature in this area.
Yeah, by clinging it to the charter.
Exactly. And I suppose some of those points you've just mentioned, Herke, bring us to the next 10 years. What, and I want to make sure we have some time for questions from the floor as well. But what do you both see as the kind of challenges ahead in the next 10 years in this more turbulent environment, Herke, as you've alluded to there? Helen, do you want to kick off on that?
Yeah, I mean, I think it's a positive thing that the EU is open to opening up the GDPR a little. I know the EU Commission, rightly in its first two evaluations, said, look, it's still early days, and it is. We've discussed that there are a lot of things that may improve over time. But I think equally it's obvious some aspects of it aren't working. So I welcome the fact that they've opened it without commenting on the merits or demerits of any of the specific proposals. What I found interesting is the polarized nature of the discussions on the omnibus proposals. I mean, you know, there are blazing fights going on between those accused of siding with industry and big tech lobbies, and then those claiming this is a deregulatory agenda and so on. And I suppose that's reflective of some of where the DPC sat in the middle of over the last 8 years. It'd probably be good, I suppose, if the discussions could be a little bit more nuanced and more evidence-based. And that comes back to some of the aspects of that article that I wrote last year on the GDPR. It is a shame that 10 years into it being in force, we still really don't have data. We don't have basic data about cross-border cases, the number of big decisions even that have been overturned in national courts, fines reduced, compensation cases. There really is very for infrastructure around evaluation systems and data collection, and I think that needs to be improved. The GDPR, for all it's good, is of course also a big regulatory burden, and that does need to be measured in some way and also factored into it. So yeah, I think it's a good thing that it's opened up for debate, and let's see where it lands. The other thing, I suppose, is you know, technology is advancing at pace. We can all remember the end of 2022 when generative AI landed, and so it has continued. So I think the EU is going to have to be open to adding new laws, even though we complain about the complexity. It's going to be necessary to address some of the potential harms. But already what's needed is some way for the existing regulators on the scene in the digital regulatory space to work better together, actual mechanisms to work better together. So laws that are without prejudice to the GDPR, but then put into what the GDPR regulates, but there's no mechanism for data protection authorities and the EU Commission to join up and give regulated entities one answer. You can just see regulated entities are sitting saying, we're being directed to do this. You know, it's privacy invasive what we're being directed to do, but there's no single answer being given. So there must be legal mechanisms that can be drafted into laws that stay parts of investigations pending the other supervisory authorities providing a response on an element of it and then moving on to a single answer. Otherwise, you know, partly it'll be exploited by the regulated entities as well who can duck and dive. So I think that just has to have solutions.
And Helen, that really speaks to the much more complex regulatory environment we're now in. And Herke, you alluded to what you're moving towards in the AI Act and some of the other pieces of the digital regulation that are already there or coming down the tracks. How do you kind of see the next 10 years panning out, both in terms of GDPR, but also that kind of interaction with that broader piece?
Well, I regret that I said yes to a request in the Netherlands to write a report about supervision in the digital area. It's unbelievable because you say the EU should add acts regulation. Well, don't worry, we will add. There's a lot in the pipeline. But the problem is all these new legislation, it also brings new supervisory tasks. But not only to the data protection authorities, but also to market surveillance authorities, to the competition law authorities. And we had to restrict ourselves in the end to 8 acts we looked at. And this is within the GDPR or in the data protection context, it is sort of quite well organized. It's very complicated, and I think it should be centralized for the big cases, but still there's a system. But the next step is DPAs having to work together with supervisors in other areas. You mentioned the Meta platform case, which was about competition law versus data protection. There, the court, I think it's an important ruling, although not everything was spelled out, but that you have to cooperate loyally, although the GDPR is completely silent about cooperating with other authorities, so outside the data protection bubble. And now you get all these other acts, the AI Act, but also cybersecurity supervision. There's really a lot. And this all together needs to work. So there needs to be supervision. And you're right that if we don't get the act together, like with the supervisory authorities, then there will companies might abuse this. But the thing is, when I looked at all those EU laws, every single law is different in the way it, for instance, requires the independence of the authority or talks about cooperation between the authorities in the same area or cross-border areas. It's yeah, in the end, quite a lot needs to be repaired in a way at national level, or at least implemented in a way which actually works. One point on the next 10 years, I hope the GDPR on the enforcement something we will see, we will need to change, but it will not be for the next years, but it will be perhaps in 5 to 10 years that this will, so many issues are solved if you do a centralized enforcement system for the bigger companies, for the cross-border situations. But you also see a stream of legislation which is exactly supporting this second objective of the GDPR. So you have the Data Act and the Data Governance Act. They're all about unlocking data. Data held by the government or data held by companies. So the Internet of Things, the data they derive from, I don't know, your dishwasher or whatever. This is all data. And the idea is to unlock it, of course, in light of technological developments like AI, which rely heavily on the use of data. And that brings me back to the court again. That's with that legislation coming behind the court in a way in future cases, they will need to link it somehow to the second objective and bring it into the equation of its assessment of ideas in the GDPR. And what worries me a little bit is, and that's a very recent case, the Russ Media case. I don't know if you heard about it. It's about a online marketplace where somebody posted an advertisement of his ex-girlfriend, and it was actually a sex contact advertisement with her picture and her telephone number, of course, without her knowing. It was on a part of the platform where there were, which was a dating site, but it was actually used for offering sexual services. Of course, he was upset about this, to put it mildly. She informed the platform, which is an intermediary service. They took the advertisement off within 1 hour after being notified, but it was also spread to other sites. And of course, then the genie was out of the bottle. They could not get it back anymore. But the question was, because this is e-commerce directive or the Digital Services Act, which has these two main issues, main points of principle. No general monitoring exercise or obligation put on intermediaries, because they become the police of the internet otherwise. They're just an intermediary, the marketplace. They cannot control everything that's put on. And the second one, an exemption from liability, unless, of course, they should have known about it. And it's a very interesting case, but the court was asked about the interrelation between the two, the relationship between this e-commerce on the one hand. And the funny thing is that GDPR actually refers to the e-commerce directive, saying it's without prejudice to those rules on liability exemption of the DSA, to put it simple. What did the court do? It parked all the questions about the e-commerce directive to the end and just started to unleash the whole GDPR approach on it. Is it a controller? Well, yes, because it also mingles with the data in the advertisement, and it actually, or at least has the right to change the substance into presentation, etc. So yes, it's a controller. It's a controller together with the one who uploads. So they need to have an arrangement. So you can. It's a fantastic case from a data protection point of view, very to the point and clearly spelled out. But meanwhile, if you come from the DSA side, you think, what is the court doing? How does this square with those two basic principles? Do they need to screen all content on whether there's sensitive data? And then they need to know whether or not there was consent, which means you have to identify the advertiser plus the person on the picture. And it's remarkable how easy the court in the end says, well, the DSA is only when it's not personal data. But that's not what you derive from the without prejudice clause here, I would say. So where we thought, because the without prejudice too in new legislation is often a sort of last resort issue, often by the Commission Legal Service to at least try to protect the GDPR. Let's say without prejudice too. But now we seem it's not in safe hands necessarily. Although with the court, perhaps yes, if it's the GDPR, but still, it's they need to bring it all together.
Yeah. And I suppose that's the problem where they're taking such big steps, one case at a time and with a particular focus. Against that backdrop is the kind of hope for simplification, which we've heard so much about in recent times, something of a vain hope. Are we likely to see any simplification in what's being proposed at the moment by way of legislative reform or otherwise, Helen?
I mean, I don't think what's in the proposals, while it's far-reaching and has caused some surprise in some quarters, it still doesn't address some of the procedural complexity issues. For example, Herke's suggestion that you would centralize enforcement in a European level supervisor isn't amongst the proposals. I did wonder in terms of your suggestion whether that central supervisor would handle all the individual complaints as well in your conception of it about the platforms and what kind of a definition you'd use to decide which cases. Would it be the VLOSs from the DSA, or have you worked through it? And how would they harmonize with what the national data protection authorities are doing and interpreting on the GDPR below that layer?
We make you EU legislator for a day, Herke. What would you do if you were trying to solve that puzzle?
Well, I didn't have time yet to write something down.
Call me when you get ready to look at it.
Oh, and again, it's just a personal idea, but I know that the idea is broadly supported. I didn't invent it. It's,
Yeah, for sure. I mean,
so in the
yeah.
EDP, actually, there are, I hear voices in EDPS. But we have examples, so like the DSA, but also in competition law, so that you, at a certain level, you just lift it to the European level. And again, it would solve so many issues. Also just an example, the admissibility of national complaints, because there's so many differences in member states. And these have not been taken away by the procedural regulation because it focuses only on the cross-border cases. But the whole time frame, so you have a draft decision, others can comment upon it. If you disagree, it goes to the board takes a binding decision. That can now be challenged before the general court. Everything pauses, the general court comes with an outcome. It might say it's wrong. Then the EDPB has to redo it again. Can it then be challenged again? I think, and then even if the court blesses it, then it goes back to the national level, and
or it's appealed to the
indeed to the Court of Justice. So it takes so much longer with this indirect system, which, and the only argument which has been really used for having this system is the independence of the national data protection authorities. Because how can it be that you then have one which sort of overrules the rest? Now we have this whole composite system of having all together deciding on. Yeah, I don't have it written down yet how to do it, but I think generally, I think we understand how.
Yeah, it's worth looking at alternatives.
Yeah, but just to say that, because we will talk about simplification in the next session, I think these omnibus proposals, they go in a sort of fast track legislative machinery.
Yeah.
So there's no impact assessment, and obviously for such a thing, such an intrusive change, you would need to have an impact assessment and think a bit. You talked about a quiet and nuanced debate about things. Well, I don't see them very often happening because everything goes at high pace. Yeah, this should be done in a proper way.
I think I'm going to suggest putting Herke and Helen into a room together for a while to trash out a good proposal and we can send forward. Thanks so much, Helen and Herke, for those contributions. We have some time for questions and answers, and it'd be great to get some questions from before. John at the back, do you want to kick us off?
On the national side, obviously there's complete gridlock in Washington. It's chaos in the United States. And so nothing of it really gets done. HIPAA, maybe a few other laws, health services, insurance regulations. Most of it is in the states, though. And for instance, in California, where I live, the California Consumer Protection Act has over 25 different laws that they've passed. And they're very protective in multiple areas. And they're also selective on the enforcement side. And also being a former circuit court judge in Florida, the big E, I call it, is evidence is what do you bring into the courtroom? What do you really have? And of course, we see that like in the Elon Musk and Altman trial, and there's always collateral issues that really don't have any play in the case. So you're talking about golf. I had the pleasure to play with some Irishmen yesterday up at Beltry, and they had scores, but I witnessed some different things on the golf course. But in any event, I did think in general, the difference, and I'm on the ABA, American Bar Association Europe Committee, so we talk a lot. We have a couple of firms, Matheson and Fry firm. I deal with Pat English over there in Matheson, but it's always great to be in Ireland. But I'll tell you, in our country, it's so much different, and or at least in the EU, you can work together, but that's just something that's, and especially what's going on in Washington, it's just so difficult there now, worse than I think I've ever seen. So I wish you all well. It's great to be in the Republic.
Thanks very much, Shane. And we've been so fixated on the European debate internally that you can lose sight of the international environment around us that has changed so radically. Anybody else, any questions for Herke and Helen? I've seen a lot of people with a lot of expertise in the room and interest. Yeah, Gary.
Yeah. At times I see as the flip side of the DPC. So whereas the DPC is about you can't do this. Oh yeah, my job is to advise on access to information requests. So I was very interested in what Herke said about the second objective of the GDPR, which is the free flow of data. And I would just add that it's not just commercial data, but it's also democratic data, because what I'm seeing, and again, this is purely in a personal capacity, nothing to do with any opinion of the office, is that very frequently public authorities will see some personal data or something that might be personal data and say, well, the GDPR says no, therefore it can't go out. And we have to then push back and say, well, actually the GDPR doesn't say no. It just says if you're going to do something, you have to have a lawful basis for it. And once you have that, you can pretty much do what you want to do as long as you can justify it. So I just found that very interesting, Herke, that it was about the flow not just of commercial data, but also democratic data.
Okay, any reflections on that? Or I know you've worked on access to information as well. Have you in your life?
Well, you mean democratic data in the sense of transparency? Yeah, I wrote my PhD about that subject, actually. Now I understand what you're talking about. So how long do we still? Now, we face similar issues, of course, in the Commission, also subject to this regulation 1049, access to documents, and there is the exception for personal data and privacy. And the funny thing is that the EDPS actually argued that there is a sort of threshold. So first, the privacy should really be at issue, undermined, before you unleash the whole data protection machinery on it. which was rejected by the Court of Justice in the Bavarian Lager case. But it showed that the EDPS at the time tried to sort of find a balanced approach to this. These are both fundamental rights. So indeed, you need to find a balance, and it's too easy to say, and we did get these questions internally. Can we argue we don't disclose because of data protection? Yeah, not always. Not always, because you also have an obligation to be transparent indeed. So the advice also of the EDPS at the time is be proactive. So don't wait for a request for access by the public, but be proactive in what you want and don't want to disclose, or at least consider reasonable to disclose. So for instance, at the Commission, if you're a director and higher, you know that your name will be disclosed on the organigram, something like this. But you need to organize that in advance and not afterwards, because then you have to ask the person. No, we have to be proactive with these issues. But still today, I get messages from my supervisor, and this is now 20 years ago. It's still not solved when there's another message in the newspaper, you know.
Very good. Any other, Emily?
Hi, Emily Egan-McGrath, I'm a barrister. Helen knows me. Just in terms of legal certainty, one thing I found a little bit hard to understand here was from the start, where you're importing competition law principles in respect to the fines, why the well-developed case law on procedural rights and rights of the defence in that context weren't sort of followed. And I think, in terms of legal certainty and the cases that are now outstanding before the General Court, some of those obligations that the EDPB refused to recognise, like the right of a controller to be heard, are now recognised in the procedural regulations. So in terms of delay and lack of certainty, there has to be a risk that at least some of those decisions fall before the General Court or on appeal, and you just have this rolling uncertainty. So I suppose as a practitioner watching this and, some experience in competition law, why legal certainty wasn't kind of achieved in that way to say, well, if you're imposing fines of this magnitude, we already know these are the rights of the defence that you have to give people. And there seemed to be kind of a refusal to accept that. And now as a consequence, this rolling, lengthy lack of certainty around the validity of some of the early decisions, which, as Helen said, potentially could have really harmonised things. But I think some of them have to be looking shaky at this point.
Any thoughts or observations from either of you on that?
I mean, I think it's the lack of implementation plan. You're right. Had there been something, the layer below the GDPR is what I'm calling strategy and good strategy, some of this could have been avoided, but there simply wasn't. There was a complete vacuum, and the EDPB and the Article 29, as it was in the period 2016 to 2018, really didn't know what was coming. And because it wasn't a regulator itself that had ever investigated anything, and some of the authorities that were members had really not got enforcement backgrounds, it really didn't know what was coming. And that left us pathfinding, as I put it, but national authorities were pathfinding also at the national level. So yeah, I would just sum it up as lack of an implementation plan.
And we see some similar issues arise under even more recent legislation as well. So there's a way to go. Any final questions for Herke and Helen? Yeah.
Hello, my name is Arnaud from Open Justice Ireland. I have a question to Herke in relation to, you said that, coming back on the question from the gentleman over there before, that the GDPR, as Attorney General Bobek say, will apply to everything. And in instance in Ireland, this is very strange, but the judgment, the decision of the courts do not always present the submission or the facts of both sides, the pleading of both parties. And at the moment, I was wondering if you have any view to which extent GDPR should apply to the correction of the decision of justice, which doesn't present properly the submission of parties, especially unrepresented parties in a court of law. And if there is any legal precedent or any case before the Court of Justice in relation to them. Thank you.
So your question is whether the GDPR allows to correct a judgment, or am I misunderstanding? Okay. Interesting question. I would say it's first of all for the court procedures to address this. If there are obvious mistakes in the presentation of facts or arguments in the ruling, then there are often, or there should be a possibility to inform the court about this. I don't think it's necessarily a data protection issue unless your name has been spelled out wrongly. But I would say that there are procedures, procedural rules for the litigation itself, right? I don't know if that's what you asked for.
If it could be pleaded under GDPR regulation.
Yeah, in theory, yes, but I don't think you should normally not get there. But just to read, there are cases of the Court of Justice where the court said the GDPR applies to courts very clearly. They are not exempted. So yes, if you can build your argument on correcting some, you have it, for instance, with publication of rulings online. Your name might be in there, so the court started now to anonymize those rulings. So Mr. Frems, the next Mr. Frems should normally not become famous because it will be a fictitious name. And we now have very weird names nowadays for these cases. But yeah, the court takes in that sense a bit of a proactive approach and takes it out. But that is an element where courts can be confronted with, I want to be removed from your register of rulings, for instance.
Thanks very much, Herke. I see our president just briefly coming in there.
Just one observation in relation to that. Under our constitution, justice is carried out in public, and the only exceptions to that are those, and there are some in statute, and there is a sort of discretion in certain circumstances that a court can anonymize a name. But regularly, we give judgments in cases where parties have claimed that their case should be anonymized. I'll give you one example. Recent decision of the Supreme Court in the High Court and in the Court of Appeal was reported under letters. The Supreme Court said, there's no legal authorization to have this under letters. So we're going to put the name of the applicant on the record. Now we know the name is Lacrimosa Amare, and that's her name. And that's the case will now be referred to as that. So I have to say, I'm not so sure. My own view is that, in fact, that the position here is correct. And the extent to which the court perhaps has maybe been perhaps not just proactive, but perhaps overzealous in this regard is certainly been a matter for debate inside the court. And I would say also a legitimate matter on which member states are entitled to take different views.
Yeah, maybe one closing remark on this, because it touched upon something which we did not really address, but you have to have a legal basis for processing. That's what Article 6 of the GDPR says. One of those bases can be a legal obligation, which is provided for by national law. And this national law must comply with Article 52.1 criteria of the Charter. So it must be necessary proportionate for a legitimate aim. And this pure construction has allowed the Court of Justice to assess the proportionality of national law on all kinds of subjects. So why do I tell this? Because this would exactly be something where normally the EU does not have rules or doesn't have the competence to harmonize this approach in principle of what do you publish or not. But through the lens of the GDPR, the Court of Justice, and in a way the Commission could also start infringement procedure, could actually act and express itself precisely on this subject. So even if they are overzealous in their own application, if one day this question comes to the Court of Justice, even though we would not have the competence to harmonize it, they might still say, you're wrong. Well, just because I had lunch with Curran before, I was talking about this Bistom of Kent case, which is about, do you have a right to removal of your name from the baptismal register of the Catholic Church? Is a cross enough, because you can still read it, or should it really be going out? And these are things which, through the lens of data protection, get on the plate of the Court of Justice. So, yeah, which actually builds on my plea that they should really not let the wind always blow from the data protection perspective, but really place them in its societal function, which is also in the research.
Yeah, so say all of us. Any final word of wisdom, Helen, before we wrap?
No, I will just mention that the Irish DPC came to the opposite conclusion to the Belgian DPA on that baptismal register case, and we decided our case first. Then the Belgian DPA found that there does have to be deletion, which is now the case gone to the CJEU.
Can I just, but so the hearing will be end of June,
Yeah,
and the commission takes the same position, I think, as the Irish DPC. But I read in MLEX, so this law newspaper, that the Conference of Bishops is worried about the case, and they have briefed the Pope about the case. So he insists on the commitments. Now we think that he might watch the stream.
But if you can watch this, it just shows me how data protection knows no bounds. Even Pontifex is not safe from it. So thanks very much to Herke and Helen for that really insightful discussion and the contribution.